My Lords, one or two questions were raised before we adjourned as to the effect of a forfeiture order and how that might be enforced against a political party. I did wonder about that before we began the appeal, and I rather expected to find in the Act a provision entitling the Commission to apply to have a party deregistered on the grounds that it was not a fit and proper party or its members were not fit and proper persons. But I haven't found such a provision. So that sanction doesn't seem to exist. The purpose of Section 60, subsection 5, which says that forfeiture proceedings shall be brought against the party in its own name and not that of its members, and that for the purposes of the proceedings related to service, it was treated as if it were a body corporate, and that any amount forfeited shall be paid out of the funds of the party, I would suggest must be to provide some comfort to members of political parties that they will not get caught by the effect of a forfeiture order. So what is the sanction? Well, it remains, even in the case of a party that can't pay, it remains very considerable, as it seems to us, because if this order were made against UKIP, and if, as is presently the case, UKIP was not able to pay it, then any potential donor to UKIP in the future would know that any donation to UKIP would have to be used to discharge the remaining the continuing liability under the forfeiture order. And so it seems to us that the effect through that indirect route, and it is slightly odd that the Act contains nothing more express, but through that indirect route, an unpaid forfeiture order would bring the political party's activities to a close. Well, I think that's, unless there's any further question that arises in relation to the terms of the Act, I think that's all I want to take you to in the Act itself. And if I may, I shall now go to the various submissions that I advance as to why the Court of Appeal's construction is wrong, I say plainly wrong, and why broadly, subject to one or two qualifications, Mr. Justice Walker's construction, more liberal construction of the section, was right. So in my speaking note, I have reached
page 6.
Page 6, thank you. And my first point is a pretty obvious one, which I won't labour, and that is that the section uses the term may and not the term shall. In our printed case, we have cited some authorities on this point. That is in the core bundle, tab 3, page 94. No, page 93. The foot of page 93. Paragraph.
Could you give us the paragraph?
Yes. Paragraph 91, page 93. Paragraph 92, it's well established that the word may, along with similar phrases, is normally to be understood as permissive, not mandatory, as conferring a faculty or power and not imposing an obligation. And that, I'm sure, is not contentious. We cite a...
This is tilting to windmill, isn't it?
I think so, Lord, yes.
It's nobody's case that may means must.
Indeed, Lord, indeed. So there are the three citations of dicta in the cases which make good a point that I'm sure is not going to be controversial. So that is that. It's not, I think, said on behalf of the Commission that this statute is one of those statutes in which, because of the context, the word may must be read as meaning shall or must. So I won't trouble the Court with the analysis of that in the case of Julius and Oxford, which is referred to in paragraph 93. What I will do, if I may, is invite the Court to compare the wording of section 58 in this Act with the wording of a different confiscatory statute, the Proceeds of Crime Act, which is at tab 52 in Authorities 4. Tab 52, Authorities 4, and it's section 6 of this Act, with which your Lordships will be familiar. And section 6 requires the court, in section 4, to decide whether the defendant has a criminal lifestyle, and to reach decisions on other matters related to the means by which the defendant acquired his assets. And then subsection 5, if the court decides under the foregoing subsection that the defendant has benefited from the conduct referred to, it must A, decide the recoverable amount, and B, make an order, a confiscation order requiring him to pay that amount. And the effect of the use of the word must is underlined by subsection 6, but the court must treat the duty in subsection 5 as a power if it believes that any victim intends to start proceedings against the defendant, and so on.
But you've rather jumped over 6.3b, haven't you?
Sorry, but I haven't intended to do so.
I mean, it's an odd style of drafting because it uses must, and then you find that one of the conditions it turns the must into a may.
Yes, well, it is an odd style of drafting. I'm so sorry. I should have taken you to 6.3b, which does rather
cut the ground under your arm.
I was going to say it rather waters down this point. It does remove some of the ground. I do accept that. However, I'm going to try and revive this point in the face of that.
So what is the point?
The point is this, Lord.
That must means must.
No, the point is this. The point is that the draftsman, as this Act demonstrates, and as is obvious anyway, the draftsman of the 2000 Act could very easily have achieved, by express words, the construction arrived at by the Court of Appeal, by using the word must or the word shall, and then imposing an express qualification which would have been very similar to the statutory defence that we've seen that applies to the criminal charge. That would, in substance, have achieved the result at which the Court of Appeal has arrived. And so my point is may means may, and there it is. I move on. Well, that's my first point as to why the Court of Appeal's construction is contrary to the intention of Parliament. My second submission is rather more elaborate. The heading of this submission is that the discretion under Section 58 is to be exercised so as to give effect to the purposes of the Act properly understood by reference to the mischief that the Act addresses. So one starts by asking, what are the purposes of the Act? And one can see that one can get assistance in relation to that from the Commission's printed case at Core Bundle tab 4, paragraph 51. The first purpose, the general purpose of the Act, as identified by the Commission, is to enhance and maintain the integrity and propriety of and public confidence in the political process. We agree, and we agree also that it is important that the Act should be construed so as not to frustrate that purpose. Come back to that general purpose, that is relevant to a subsequent submission I want to make. But then turning to the specific purposes of the forfeiture power supplied by Section 58. The first such purpose that the Commission identifies is the deprival of the wrongful gain made by parties in accepting and retaining an impermissible donation. We agree up to a point. The applicability of, or the relevance of that purpose depends on what is meant by wrongful gain, and I'm going to submit in a moment that the concept of wrongful gain has to be assessed by reference to the mischief at which the act is directed. Second specific purpose, deterrence. We agree, we accept that one specific purpose of this section is to deter parties from, in the future, contravening the provisions relating to donations. The case at Little Roman 3 does seek to identify a third specific purpose, the need for a simple and effective sanction to enforce the prohibition on acceptance and retention of impermissible donations, prevent evasion of those restrictions, and deter such breaches in the future. As we read that really largely duplicates the second specific purpose, namely deterrence, and so we don't think that there's any substantial further purpose identified there. So we have one general purpose, which is most important, and two specific purposes, deprivation of wrongful gains and deterrence. Now, for the court to understand how those purposes, the identification of those purposes should inform the construction of the Act, it's essential in our submission to identify the mischief at which this part of the Act is addressed. And this is something we respectfully submit that the Court of Appeal's judgment doesn't do, or certainly doesn't do in any very substantial or satisfactory way. Can I take the Court, please, to an extract from Professor Benyon's book, which is in Authorities 3 at tab 48. And may we turn, please, to page 918, which is towards the end of the extract that has been copied. At that page 918, Professor Benyon takes us back to the 16th century and to the famous Hayden's case, which laid down the mischief rule in resonant language. The rule, or the formulation provides that suggests that the proper interpretation of statutes should involve 4 steps. What was the position before the making of the Act? Well, we know what that was in this case. There were no prohibitions on the acceptance of foreign donations. What was the mischief for which the common law did not provide? It failed, said the Neal Committee, to prohibit foreign donations which were undesirable for the reasons given. What remedy has Parliament provided? Well, we know that. It's provided the regime that we find in the relevant part of the Act concerning permissible donors, etc. And then 4, the true reason of the remedy. And I focus on that phrase because that identifies what is an absolutely critical part of the process of construing this Act, which is to recognise that the mischief is not the same as the remedy. You have the remedy, which is the statutory regime relating to permissible donations. You have the underlying mischief. They're not the same things. And if one turns on...
Well, they'll never be the same thing. They're not diametrically opposite each other.
No, indeed, but they're not. They won't be the same things. But there can be a gap, as it were, between the the scope of the mischief, or a difference between the scope of the mischief and the scope of the remedy. And Professor Benyon goes on to make that exact point at page 929.
929.
929, Lord, yes. Heading section 295, ambit of the mischief. In using the mischief for the purpose of interpretation, it may be important to determine, so far as necessary for settling the point at issue, the precise scope or ambit of the mischief Parliament intended to remedy. And then if one passes over the example given, and one arrives about 2/3 of the way down the page, one sees this. The wording of the enactment may go wider than the actual mischief for some extraneous reason. It may, for example, assist enforcement of the enactment if it is worded more widely than is legally necessary to remedy the mischief in question. Common sense may indicate that the ambit of the mischief is narrower than the literal meaning. It is, my lords, a very obvious point, but it's one that the Court of Appeal, we respectfully say, did not pay sufficient attention to. The fact is that the mischief here has always been the prohibition of foreign donations. One draws that from the Neal report. There's nothing in the white paper which we discussed this morning which affects that conclusion. And one can draw that also directly from the explanatory notes that accompany the Act, and they can be found...
Well, sorry, just before you
Yes.
pass from this passage, I mean, just what happens when, in fact, that is the position, and the ambit of the mischief is narrower than the literal meaning, but if the literal meaning is if it's there designed to assist enforcement?
Indeed, my Lord, and the existence of the remedy that Parliament has provided here creates what you might call a secondary mischief. Parliament has created this regime, and we accept that it's desirable, very desirable, that political parties should comply with that regime. They should observe the rules, and they can't simply ignore the fact that the test changed from eligibility to actually being on the electoral roll. They have to observe the rules. I quite accept that. And that's why we accept that one purpose of the section is to deter or to keep parties up to the mark. And in acting to promote that purpose, the court is bound to have regard to the desirability of causing parties to comply with the rules. And so in that sense, the remedy has created a secondary mischief here. But the primary mischief at the core of the Act, which underlies the Act and which brought the regime into existence in the first place...
Does Mr. Benyon tell us anything about primary and secondary mischiefs?
No,
I see.
not in terms of the law, but the classification is mine, but I do maintain that it's a valid one. And one can see how that distinction operates when one turns back to look at the two specific purposes of Section 58 that have been identified by the Commission. The first purpose is deprivation of wrongful gains. Now, the Commission's position on this is put by reference to the Fibrosa case. And if one looks at paragraph 53 of the Commission's case, page 158, paragraph 53, one sees that they cite a passage from the Fibrosa in support of their position on the deprival of wrongful gains or the reversal of unjust enrichment.
Well, I'm bound to say for myself, I think deprival of wrongful gains is not particularly helpful here. And the party might be making money by prostitution. And if you said that the money should then be taken away, that might be deprival of wrongful gains. It's plain as a pikestaff. At least a primary object is that foreign persons should not be able to influence politics by providing money. And
Yes.
what's plainer than that? And therefore, if they provide the money, you take it away to stop that happening.
Yes.
How does it help to call those wrongful gains? It merely confuses the picture rather than clarifies.
Well, Lord, I do respectfully agree with that. It would be better to talk about depriving the party of a benefit that it has received that is within the scope of the mischief that the Act is directed at. And that means depriving the party of a foreign donation. And we accept, we indeed submit, that in any Section 58 application, where the monies received by the party do amount to a foreign donation in the true sense, then that would militate strongly in favour of a forfeiture order in relation to the entirety of the donation. We accept that. And that we would suggest is the way the Act is designed to work. But the reason I've gone to the Commission's reliance on the passage from the Fibrosa is that the text that they cite refers to a benefit derived from another which it is against conscience that the recipient should keep. And we make the simple submission that it is for the fact-finding tribunal that hears the Section 58 application to decide, having regard to all the circumstances of the case, whether it is indeed against conscience that the recipient party should keep the benefit of the donation that has been made. Usually it will be, quotes, against conscience, where it is a foreign donation and therefore within the scope of the mischief that the Act addresses. But whereas here it is not a foreign donation and it is plainly outside the scope of the mischief, then normally the court will simply put to one side the so-called wrongful deprival of wrongful gains purpose. They will simply treat that as irrelevant and they will should move on, to the question of deterrence and keeping parties up to the mark.
I mean, I suspect that the phrase wrongful gains in 53 is simply a translation of impermissible donation, which is the statutory concept which is in play.
Yes, well, I
don't think you lose anything by using the statutory language in 53.
No, it could be put, the purpose could be put as the deprival of an impermissible donation. And the value judgment for the court hearing the Section 58 application then becomes, well, in all the circumstances, do I in my discretion, the judge says, do I in my discretion think it's right to deprive the party of this benefit? And if it's not a foreign donation, and that benefit could very readily have been given by the donor simply by means of filling in a form and sending it off to the registration officer, then the court hearing the Section 58 application may well say, what's the fuss about? This donation is not a foreign donation. It's well outside the scope of the mischief. There's no real problem here in the party retaining the benefit of the money. And the jurisdiction then becomes a quite different one. The court then moves on to the second purpose, looks at the question of deterrence, recognises that the regime is a fairly straightforward one, with which parties must be encouraged to comply, and then pauses, looks at the resources available to the party, looks at the party's position, the likely impact of any order, looks at the party's record of compliance or non-compliance, etc., etc., and comes to a judgment as to whether it is necessary or proportionate to make a forfeiture order at all, and if it is, then if it has a discretion to make a partial forfeiture order, it can do so to achieve the end of proper proportionate deterrence that we accept is appropriate. So that is the way, in summary, we say this discretion and this jurisdiction should operate. And we don't accept that in a case of this type, the so-called deprivation of a wrongful gain purpose is really, in any sense, engaged.
It's some sort of civil penalty, is it?
I'm sorry, Lord?
Some sort of civil penalty.
Yes.
Is that what it is? I'm just trying to see what this forfeiture... I mean, I'm not familiar with sort of civil forfeitures of this sort. I mean, it's not criminal, it's not confiscation of assets, it's not like forfeiting a car which has been used in a crime. It's not criminal courts doing it. So, I mean, what are we talking about here? I mean, you seem to accept that it's a penalty of some sort.
I do, yes.
Even though it's in the civil court.
It's essentially, it's a penal measure, yes.
That's your approach.
That is the approach the Act takes, yes.
I mean, you cite in another context these various cases, I can remember, all about confiscation of imported stuff and all the rest of it. I mean, is that a useful analogy? Is that a parallel? Is that a civil forfeiture? What's that?
It is a useful analogy. The case, there are two cases involving the seizure by the customs of cars used to bring tobacco back into this country.
What's all that? Is that same scheme?
Well, it's a different scheme.
We got it here?
We've got it, my Lord, and I'll go to it, yes. My Lord Phillips was
and the difficulty with those cases was that what the customs were forfeiting was vehicles which were worth a good deal more than the goods being brought in contrary to the rules.
Yes.
So it doesn't really help you very much, those cases, in that sense. It can be said that what is being forfeited is precisely equivalent to the amount which actually you shouldn't have had the benefit of, one way or the other.
Yes, that is true. It's a donation that, under the rules, we should not have received. But taking a broader view of the position, the benefit represented by that donation was a benefit which it was readily open to the party to obtain by lawful means.
Yes, I mean, you come back to your basic point. It's not within the primary mischief, and
yes, I do.
Insofar as there's a secondary mischief, I suppose it is that unless you have a clear-cut rule like registration, there may be uncertainty and difficulty in ascertaining whether something is a foreign donation.
Yes.
And therefore, you fall back on a clear-cut rule. But in the present case, we know perfectly well it isn't a foreign donation.
Yes. Yes, there are good pragmatic reasons for having a so-called bright lines rule that the parties should be able to comply with. I accept that, hence the need to deter parties from not complying with that regime, and from that flows the submission that I've already made. But at any rate, Your Lordship has my submission in relation to so-called wrongful gain.
You do need your halfway house, really, don't you? Otherwise it becomes very, very difficult to reconcile proportionality if it's all or nothing, with the secondary mischief.
Yes, if there does not exist a discretion to forfeit part, then the court is placed in a very difficult position. It will come to a case like this, properly informed as to the law, it will come to a case like this, aware that it's not a foreign donation, and therefore outside the scope of the primary mischief, aware that the parties should be encouraged to stick to the rules, wishing perhaps, on appropriate facts, to impose a modest penalty to deter and keep parties up to the mark. But if it, in fact, is constrained to say all or nothing, then it will have to say to itself, well, acting lawfully, pursuant to the Convention, I must act proportionately. Since I am constrained by the Act to say all or nothing, if I decide that all is disproportionate, I have to say nothing, even though I feel that the purposes of the Act should impel me to impose some sort of penalty here. And that tends to suggest that the all or nothing construction does not really do justice to the underlying purposes of the Act.
Is there any provision anywhere about forfeiting not something, but part of something? You can't forfeit the spare wheel of the car. What can you... Is it all or nothing generally? I mean, is this...
Well, in relation
would this be a new creature, a partial forfeiture? I don't know.
Well, in relation to the customs cases, I don't recall any provision for partial forfeiture there, my Lord, no.
But is there in any other area of the law? I mean, it's quite important. The concept here is forfeiture, not sort of civil penalty.
Yes, well, it's described as forfeiture, but in substance, it's a penal measure. It is saying not the court can seize that piece of land or that specific asset. It is saying that the court can forfeit a sum equal to the value of the donation. It is saying also the court may decide to forfeit nothing at all. The court is given a discretion to move to that end of the spectrum. And I'm moving ahead of myself here, but our simple submission is that if the court can forfeit everything and can forfeit nothing as a matter of discretion, then the greater includes the lesser, and it is implicitly
Well,
open to the court.
I follow all that. I
the
mean,
fourth
the
and part.
oddity of this case, as I understand it, is that actually, I mean, we don't know what the individual sums were, but the statement of facts and issue simply tell us that the impermissible donations amounted in all to 350,000 odd. For all we know, there were 35 of 10,000 each, in which case, you know, why can't a magistrate say, OK, well, you can forfeit some of them, but not others?
Well, there were a large number of different donations, Lord, and that would be a pretty unsatisfactory indirect route to a partial forfeiture order. It might be said that that was an irrational response to the problem because subject to questions of timing, what would justify the magistrate in forfeiting some of the donations given in the first 3 months of the year and not others? But
each donation is treated separately under the Act.
Under the Act, yes.
So there's a separate, quote, cause of action, unquote, in respect of each unlawful donation.
That's right, Lord. It would
So
be very...
you don't really need your all or nothing point, do you? Because you could say, well, as my Lord suggests, you could say, well, a fair number taken overall would be X. I make the exercise of my discretion. I shall forfeit all of the forfeiture of X. That's to say, made up of the following 10.
You could do that, Lord, on the facts of this case, but we obviously, and the court will be trying to make sense of the Act, and it would be very odd if the ability to impose an effective partial forfeiture order depended on whether the donations were broken up or delivered or given in one lump sum. That would be curious. So...
This juncture, there was evidence as to sequence of donations, and we thought it might be, as your Lord had a little chart showing what was given when. It was all evidence before the district judge. I don't know if you've seen it. If your Lordship wants it now, we can hand it in, if not at a later stage.
I'm not sure we need the details. It's nice to know. We know they're there anyway. Yes. Yes.
Yes. Well, I'm sure my friend can pass it up in due course if it assists. Lords, Lordships have my suspicion about wrongful gain, so-called, and the primary mischief. Can I canvass this point with your Lordships? The Court of Appeal has indicated that a party might be able to defeat a forfeiture application by returning the donation out of time, but before the forfeiture application is made. They say, well, that in those circumstances it would not be right to make a forfeiture application because it would not be right to cause the party to pay out twice. Take this type of case where the donor is potentially permissible because he's not a foreign donor. Suppose that two different parties, Party A and Party B, received at the same time the same type of impermissible donation from somebody like Mr. Bowen who could be placed on the electoral register. Suppose that the Commission raised queries about the donations and intimated that there was a danger that a forfeiture application might be made. Party A, well advised and in funds, would return the money to the donor, inform the Commission that it had done that, and then either the next day or after a decent interval would receive a further donation, a lawful donation from the donor, thus restoring to it the benefit in question. Party B, either because it was not in funds or because it was less well advised or because it took the robust view that this wasn't really a big problem because the donation was not a foreign donation, did not take that rather artificial step of causing the funds to move round in a circle until too late. The forfeiture application comes in, is served on Party B. According to the Court of Appeal, the position of those two parties is very different now. Party A has provided itself with a defence to the forfeiture application. Party B has no defence because it's too late now, says the Court of Appeal, to return the money. That is very odd. And that analysis, and one can develop the hypothesis, but I won't bore you with it, but that analysis indicates that the Court of Appeal's failure to have regard to the nature of the primary mischief here has led it to reach a construction that places form over substance. And the task of the court, the eye of the court construing a statute should, we submit, like the eye of equity, look at the substance of the matter and not at formalistic movements of money of the type that I have canvassed. The core point here is it a foreign donation? If it is, it probably will be liable to forfeiture. If it's not, then the Section 58 court is, we say, in very different territory. Third reason why we say Court of Appeal got it wrong, we invoke the rule, so-called rule against doubtful penalisation. We have identified authorities on this point at paragraph 64 of our printed case, which is tab 3, page 85. This will be very familiar territory for my lords, and indeed some of your lordships were in the case that was drawn to my attention this morning, the recent decision in the Sainsbury's case, where these principles were considered.
So which paragraph?
I'm sorry, Lord, paragraph 64 on page 85 in our printed case. Does Lordship have that?
Yes, okay.
Ambiguities.
Sainsbury's, you say?
Lords, some of your lordships were parties to a decision in a case about compulsory purchase that was decided
Absolutely.
3 weks ago. No, I haven't referred to it here, Lord, because I really learned it
I
this
know, but
morning.
I mean, I didn't know it had anything to do. I must have missed that point.
Surely not.
I think my lord was dissenting.
Your lordship might not have read the judgment of Lord Collins with the care that it deserved, because your lordship didn't agree with that judgment. But I'm sorry, Lord, I didn't mean to. Didn't come out quite the right way. The judgment of Lord Collins in that case does contain a very convenient summary of the principles in this area. But unaware of that, we have cited an old case, Methuen and Campbell and Walters, which is in the authorities at tab 24. I won't go to that. I simply mention it.
Have we got Sainsbury's? I mean, it's high time I read.
I will bring it tomorrow morning, Lord. We haven't got it today, I'm afraid. I won't go to Methuen and Campbell, but it makes good the well-known and I think not controversial proposition that we are putting forward. But I will ask your lordships to look quickly at authorities tab 33, which will be in 2 or 3? In 3, yes, authorities 3. This is a decision of Mr. Justice Sullivan in the Assets Recovery Agency against Green, and I can go straight to paragraph.
This is the same Green as one of a trilogy came to the Lordship's house as a criminal confiscation case.
I'm not sure about that, my lord.
I think so.
I'm not sure. It may well have been. If one goes to paragraph 43, Mr. Justice Sullivan there cites a short extract from Halsbury's. An act should not therefore be construed so as to interfere with or prejudice established private rights under contracts or the title of property unless it is clearly intended to do so. And then moving on to paragraph 44, the third sentence of that paragraph reads as follows: I can see no reason why the rule against doubtful penalisation should not apply both to the principle whether an enactment is intended to have expropriatory effect and to the procedure whereby expropriation is to be effected. And we we say that if your lordships were in any doubt as to whether to agree with Mr. Justice Walker that there is a relatively broad discretion here, or whether to agree with the Court of Appeal that there is a strong presumption in favour of forfeiture, that rule should point in the direction of the learned judge's analysis. Well, that's point 3. Point 4 is a rather different sort of point, and I may have to meet an objection by my learned friend that I should not be permitted to take this point, but if I may, I'll tell your lordships what the point is, and then I'll deal with that objection if it's seriously advanced. This point is advanced under the heading Public Confidence, and I begin by going back to the general purpose that the Commission has identified as underlying the 2000 Act, namely maintaining and enhancing public confidence in democratic processes. Given that it's common ground that general purpose underpins the Act, the Court, in construing the Act, must ask itself this question. In relation to the two competing constructions for which the parties respectively contend, will each construction promote or undermine public confidence in, if you like, political processes in this democracy? And we do submit that the Court of Appeal's construction is liable to undermine public confidence in political processes. Why is that? If the Court of Appeal is right, then the Commission has a wide discretion at stage 1 of the exercise that entitles it to decide in one case to bring a Section 58 application and in another not to bring a Section 58 application. Clearly, the exercise of that discretion would potentially be susceptible to judicial review proceedings, but such proceedings would be problematic in various ways. There's a shortage of time to bring them. There's a shortage of information because the public don't know much about the decision-making processes of the Commission, and there are obvious costs, risks, which may deter members of the public from embarking on such uncertain litigation.
Where do you get this wide discretion? Because you accepted this morning that the logic of the Commission's proposition was that it must have a very narrow discretion, and in the passage you cite on page 99 in little 5, the Commission isn't saying it has a wide discretion, at least not necessarily. It just says it has considerable expertise and can be expected to act with a proper sense of responsibility.
Lord, yes, I took it. I took it from the observations made by counsel for the Commission in front of the senior district judge that the Commission did treat itself as having quite a wide discretion to consider all the potentially relevant circumstances before deciding whether to make an application or not. And there is material, I think, in the Court's papers which indicates that a number of possible forfeiture applications have been considered by the Commission over the years. But I think I'm right in saying that this is the only application that has come to court. I'll be corrected if I'm wrong about that.
Does that appear in the transcript that they said they consider themselves as having a wide discretion?
Yes, I took your lordships to a passage in that respect. Yes. Shall we look at that? It's Appendix 2 CD, page 754.
Page what, sorry?
754.
Thank you. Yeah.
It's the passage from line 14 down to 22. That, of course, would depend on the circumstances, size of donation, knowledge, intent, and essentially the circumstances, but that is for the Commission, and it has its own policy in terms of dealing with the matter. I shouldn't, my Lord, be taking...
This is just a transcript of extemporary things, because only a few lines before they say what matters is what the court decides to do. I mean, are we to take this as particularly binding?
No, Lord, it wouldn't be fair for me to try to hold the Commission word for word to what was said by counsel on his feet in front of the district judge. One just does take from that passage an indication that the Commission regards itself as having a discretion. Your Lordships will hear from my own friend in due course as to the Commission's perception.
I mean, they may be wrong.
I'm sorry, Lord?
Even if they do regard themselves as having a wide discretion, they may be wrong about it.
They may well be. They may well be wrong, Lord. They may well be, and it may be that their discretion is a very narrow one. I wouldn't quarrel with that, but if their discretion is a very narrow one, then that would strongly support our submission, which is that the court's discretion is a wide one, because it is the court to whom Parliament has chosen to entrust the discretion that is definitely required here to enable a proportionate result to be achieved.
So you say if their discretion is a wide one, then the court must equally have a wide discretion. And if their discretion is a narrow one, then the court must have a wider one. So neither.
I try to catch them on the fork, my Lord. If their discretion is narrow, then the court should be wide. If theirs is wide, then it is highly inappropriate and damaging to public confidence, etc., for the courts to be narrow, because that involves moving all the power from the courts to the Commission.
It rather depends upon whether the scheme is that they should have the primary discretion or the judge. If they should have the primary discretion, then one would think the role of saying that the judge has got to take the final decision is that the judge, once they have referred it to him, will be checking that it's been appropriate for them to act.
Yes.
But if, on the other hand, it's the judge who has the final discretion, then it's much more easy to envisage that they should be referring anything where there's any doubt at all to the court. So that the court then resolves the doubt as to whether it's appropriate or not.
My Lord, yes. And that second position is the one for which we contend. That is what the Act envisages, where it gives this, on its face, wide discretion to the court. That is what Lord Neil unquestionably had in mind when he went to the trouble of expressly setting out a recommendation that the Commission should in no circumstances act in a judicial or quasi-judicial way. And that is what is required to promote public confidence in this area. I'm going to go now, my Lords, to a decision that the Commission, the decision that I've already spoken of, that the Commission made in relation to the donation to the Liberal Democrats. I made it clear in our printed case, and I make it clear on my feet, that I'm not to be taken as alleging actual bias or anything of that sort against the Commission in relation to this decision. It may have been a perfectly good decision. I don't know enough about it to develop a submission, even if it were relevant to do so. But my point is that when we look at the circumstances of the decision in relation to the Liberal Democrats, we will see that the Commission has to take delicate and sensitive decisions, and potentially very controversial decisions, in relation to Section 58 applications. And it has done so in respect of the donation to the Liberal Democrats. And if the position was, as the Court of Appeal has found it to be, namely, the Commission has its discretion, but the court is more or less a rubber stamp, subject to checking that the donation was impermissible, then that will foster, that is in danger of fostering a perception amongst sections of the public that one political party is being favoured in unacceptable ways by an unaccountable, less than transparent body. And that would be most damaging and most inappropriate.
I mean, the difficulty seems to me that you have with Mr. Brown as opposed to Mr. Bown is, Mr. Brown, the question is, yes or no, was he a permissible donor? It's a Section 54 problem in his case. There isn't any question as to the exercise of discretion whether or not to pursue him under 58.
Mr.
Brown... The question is, was the company was an English company?
Yes.
The question, therefore, was under Section 54, or did it fall as a permissible donor within 54 too?
Well, there were two questions, my Lord, in relation to Mr. Brown. The first was the English company a permissible donor? And that depended on an analysis of the question whether the company was trading at the relevant time. The second was whether the donation should, looking at the substance of the matter, whether the donation should be treated as the donation of Mr. Brown or his foreign company, each of which were impermissible donors, the donation having been channeled through the English company. There were two matters that the Commission had to
They
look
were
at.
the earlier stage, both of them.
Yes, indeed. And the Commission plainly took some advice on the matter and came to they say in their press release, that they came to a view that there was no reasonable prospect of making good a Section 58 application. Can I just put a little bit of flesh on the bones of that, my Lord?
Why does it help? I mean, we've got 3 pages in your case
yes.
with Mr. Brown. We can't possibly construe the statute by reference to this, perhaps for your party or your client's party, exciting comparison. It seems to me the only points that matter are 121 and 122, where you try and state a principle. I think you've already covered it.
Lord, yes. I think, my Lord, I accept that it's not necessary for this court. I do accept that it's not necessary for this court to look in detail at the facts of the Brown case. All I seek to establish by putting that example before the court is that there will be, from time to time, cases which could go either way. The Commission could take a decision that there's an arguable case and it should be placed before a court, or it could perfectly properly go take a different decision. That's going to happen and has happened in the Brown case. And if it's
well, not quite, as my Lord's pointed out, on a different ground, but it could happen. All right, it could happen.
My Lord, on a different ground, yes, I quite accept that. The question in relation to Mr. Brown was different to that which arises in this case, but that doesn't affect the thrust of my submission.
But your case all depends upon what could happen. It doesn't involve after deciding what did happen
Exactly.
in some other case.
Exactly.
So we really, although it has a certain entertainment value, we should be focusing on the underlying principle and moving on from there.
We should, my Lord, and entertainment value notwithstanding, I quite accept that I'm interested, and the court should be interested, in what might happen, and I've simply had the opportunity of using an actual example to demonstrate to the court how things might work. But the point of principle, which I think has been conveyed, the point of principle is that these issues about Section 58 and whether applications should be made, and if they are made, what their outcome should be, perhaps won't arise very often. This is the first Section 58 application to come before the court. But when they do arise, they are, from time to time, going to be very delicate and controversial matters indeed. And one can, again, see that by considering what the repercussions might have been if the Commission had taken a different decision in relation to the Liberal Democrat donation towards the end of last year. So these are matters that the members of the public who are interested in political affairs are going to be monitoring very closely.
So does that mean it depends whether you give your donation just after an election or whether it's within 5 months of an election or something like that? The different issues arise as to whether to make an application for forfeiture, because it might be terribly annoying to the party to be without funds when there's an election on.
Yes.
That would be a relevant matter.
For the Commission, my Lord,
Yeah,
or for the court?
For the court.
For the court?
Yeah.
Well, yes, the impact of a forfeiture order on the political party is a potentially relevant consideration.
Why?
Because the court must have regard, if the court is persuaded that the making of a forfeiture order in relation to the entirety of the donation would effectively put that party out of business.
It's got no business in being business if it's only in business because it's got a donation from a foreign donor. I mean,
Well,
why should it be allowed to carry on and conduct a campaign on the basis of a foreign donation?
If the donation is a truly foreign donation, my lords, then I don't seek to...
So this only applies to your kind of case?
Applies to my kind of case. I've accepted that in cases of true foreign donations, that factor, there might be exceptional cases, but generally speaking, that factor will militate very strongly in favour of forfeiting the lot, because the party shouldn't...
Irrespective if it's the day before the election?
Yes, indeed. It's conceivable that very unusual circumstances might arise which would caused the court to look mercifully on the party's position. But generally speaking, the party shouldn't have had that money, and it should be paid out, yes.
Surely the big distinction is whether it's spent the money or not. I mean, if the application for to forfeit were made before an election and the party still had the money and it could be forfeited, then one would have thought it fairly obviously it was a strong case for forfeiture. But
yes.
If the party, maybe negligently, but in good faith, had actually spent the money and was going to be forced to stop electioneering, that might be a different thing, you would argue, I would suppose.
I would, I think, my Lord, and the Liberal Democrat position is instructive here, because they would have said, if the application had been made, well, this donation was received 4 years ago. It's taken you, for whatever reason, 4 years to make your mind up about the matter. We've spent the money is long gone. We're now approaching an election. You said 3 years ago that you accepted that we'd acted in good faith. All these matters have to be weighed in the balance before you decide effectively to put us out of business, or at least to disable our campaigning by making this order. And the court should be allowed to hear that submission, weigh it up, and then decide.
I find it very strange. I mean, it strikes me that political parties, like football clubs, regard themselves as exempt from the normal laws of insolvency.
Absolutely right.
Well, I did, when my Lord Mance suggested that it mattered whether the party had spent the money, I did sort of privately reflect that it seems that all these parties are always in debt, and so the money is always swallowed up the moment it's paid over. But maybe some are better placed than others. I think the public confidence point, which we do place quite close to the centre of our submissions, has been made. The one further gloss I would place on that point arises from the provisions in the Act relating to the appointment of commissioners and relating to access to the commission by the parliamentary parties panel. Those provisions may have, probably do have, a very solid pragmatic justification, but they create the perception that the established parties, i.e. those with two MPs or more, have rights of access to the Commission and rights to appoint commissioners, which are not shared by fringe parties such as my clients, who do not have two MPs. And that is a small additional factor which enhances the risk that some members of the public might not unreasonably think, where a commission takes a decision one way in relation to one party and a different way in relation to another, might not unreasonably think this is a case of the political class, the established political class, looking after its own. And it's really hard to think of anything that would be more damaging to the engagement of the public generally in political processes. That perception has to be avoided. It should be avoided by honouring Lord Neil's careful recommendation that the Commission is not to take on judicial or quasi-judicial functions, and by restoring to the court hearing this type of application the wide discretion that we say it should have. Well, that's public confidence. That leaves my fifth point, which I have covered already, which is that the Commission is not and should not be seen as a court, and I base that on the passage in the Neil Committee report at Appendix 3, page 333, which we have already looked at. So, Lords, there I have put to the court 5 separate reasons why the Court of Appeal's construction is wrong and potentially damaging, and why, broadly, Mr. Justice Walker's decision as to the width of the discretion is to be preferred. Can I now move to a point that we have already touched on, I've already touched on in argument, which is the all or nothing point. Our submissions on this, which...
Just before you get to that, I mean, the White Paper certainly thought, we looked at it earlier, that seeing whether someone's on the electoral register is both conclusive and simple to administer. It would be far less straightforward, they say, to verify somebody not appearing was nevertheless entitled to do so. I mean, I don't know at all. I mean, this case, everybody agrees your chap was wrongly removed, he should have been there. But, I mean, I don't know, in a general case, how difficult is it to check whether... I don't know what I can't remember what the touchstones of eligibility are and all the rest of it. I mean, I suppose questions of domicile arise, do they? I don't know. What are the complications of actually seeing notionally whether somebody was entitled to have been on the register?
Well, it would not be, in fact, be that complicated, my lord. You have to be resident in this country and you have to be a citizen of this country, or I think a Commonwealth citizen. Being a citizen of an EU member state is not sufficient.
Wait a minute, it certainly is. Certainly is sufficient to be registered if you're a citizen of an EU state. If you're resident here.
You have to be resident.
You have to be resident here.
In relation to parliamentary elections?
Not parliamentary.
No, for local elections.
No,
to get on the register.
I
mean, that's one of the features of this. There's no distinction between parliamentary and local, is there?
Is absolutely right. The point I was making related to parliamentary elections, that's the context we've been dealing with. But in terms of the register...
Yes, the register is simply something which applies to either.
Yes.
Yep.
And the Act doesn't, of course, distinguish between the register for parliamentary elections purposes and other elections purposes. So...
But are there two registers, only one register?
One.
There's one register.
One register.
One,
yes.
I believe.
So if you're on for European purposes, are you on? Is that good enough for this purpose or not?
I should know the answer, Lord, and I shall be frank. I don't know the answer. I will supply you with the answer.
I think it must be. I mean,
even though you can't vote in a British election.
Supreme Court justices are in that odd
Yes,
position.
they are, exactly. But
Members of the House of Lords as well.
Yes.
the white paper far less straightforward. It implies to me that it's not sort of a simple question in all cases, yes or no. Are you entitled to be on the register? I don't know.
Well, it's certainly a less straightforward inquiry, obviously, than...
Quite. But they say far less.
I would have thought it would be fairer to say less straightforward than...
Well, there are various things, in particular in relation to foreigners, because you can continue to be registered here, even if you're resident abroad, provided you're a UK citizen and you've been resident in this country within the last, is it 20 years? I mean, or there's some historical test.
It's something like that, Lord.
And that would clearly be very difficult to check.
Yes, yes. Lord, I'm sorry not to be more helpful. We have, in the past, we have both looked at this, but we haven't placed in the authorities bundle the relevant provisions, and we'll look at that overnight and make sure that the court is informed tomorrow.
But you might argue that the effect of the route that's been chosen in this legislation is really to reverse the burden of proof because of the difficulty of establishing that one is local as opposed to foreign.
Reverse the burden of proof?
Yes, I mean, the Commission can simply say that there has been here an improper donation because the individual is not registered. Now, it's up to you if you want to put forward a case, well, that's not all that serious because actually the individual could have been registered, then the burden of proof is on you to do so.
Indeed.
Whereas if you'd had the original scheme, the burden of proof would have been the other way, wouldn't it?
The Commission would have to have, it would have been very difficult for them because they would have seen a name in the donation report and an address. But to check whether that person was eligible to be registered, given their ignorance of his circumstances, would have been a very onerous burden. So one can see the pragmatic sense in simplifying and narrowing the test, the criterion. And I, of course, respectfully adopt what your Lordship has said. In practice, when the application is made, in our type of case, the burden is firmly on us to show that this was not a foreign donation, did not offend against did not involve the relevant mischief. We have to call evidence from Mr. Byrne or evidence about him that shows that he was a local, a domestic donor, which we did. We put in a statement, and he was not challenged on that.
I deflected you from going to the all or nothing.
Well, thank you. The submission on this aspect of the appeal, our submission, starts at paragraph 58 in our printed case. And for the moment, I'm going to limit my submissions to common law construction of the statute. I'm going to come, having done that, and I'm going to turn to the operation of Section 3 of the Human Rights Act, in this case, as it applies to both the all or nothing and the presumption issues. So looking at the all or nothing issue in terms of pre-Human Rights Act techniques of construction, I make these 2 points. First, I advance the submission that the language of the section is capable of being read as conferring on the court a discretion to forfeit part, but not all, of a donation. And I rest that submission simply on the principle that the greater can include the lesser, and that if the court is to have the power to forfeit all and to have the power to say there should be no forfeiture at all, there is no rational reason why the court should not impliedly have the power to forfeit part. Secondly, I rely in this area, as I have done already on the issues as to width of discretion, on the common law rule against doubtful penalisation. I say that that broad principle or presumption militates in favour of a flexible discretion that enables the court to avoid a disproportionate and unfair forfeiture by forfeiting part but not all. Those are the 2, as it were, common law points I make in relation to the all or nothing issue. But I should, I think, enter a qualification to what I've submitted. It has occurred to me that it would be open to this court to say, well, it's not necessary to protect, in order to protect the political party against a disproportionate outcome, it's not necessary for us to override the apparent meaning of the words used in the statute, and to hold that partial forfeiture is possible, because we can say that the court's discretion is all or nothing, but that if the court considers forfeiture of the entire donation to be disproportionate, then the court can simply and must simply say there shall be no forfeiture. That is an alternative approach which would protect the legitimate interests of the party that was on the receiving end of the forfeiture application, and it is one way of construing this Act. But having said that, we do submit that in order to make sense of the Act in a way that enables the court exercising the jurisdiction to achieve a result that is both proportionate and is liable to promote the purposes of the Act, it is appropriate for the court to apply a purposive construction that permits partial forfeiture. My Lords, I now turn to the possible relevance of Section 3 of the Human Rights Act to this case. Can I start this part of my submissions by saying emphatically that our primary position is that this is a case in which Section 3 is not engaged. It is not necessary for Section 3 to be engaged here, because for all the reasons that I have already submitted to the court, quite apart from Section 3, old-fashioned common law principles of statutory construction enable the court to reach the right conclusion, which is to hold that the section confers a broad discretion and to hold that the section enables a partial forfeiture order to be made. If that is right, then the court can simply, and obviously, place Section 3 to one side, because if the discretion is broad, and if the court can forfeit part of a donation, then we accept that convention rights are not engaged. There would in those circumstances be nothing constraining the court to reach a conclusion that unjustifiably interfered with the parties' convention rights, and therefore there would be no room and no need for Section 3 to be engaged. So that's our primary position, and that's the conclusion that I respectfully urge the court to come to. If that submission, or the submissions that I have already advanced, are not accepted, and if this court is persuaded by my learned friend that, absent Section 3, the Court of Appeal's construction is correct, then Section 3 potentially is engaged. On the basis of the Court of Appeal's construction, the position, as we've discussed, the position is that there's a strong presumption in favour of forfeiture. The court, in almost all cases, is no more than a rubber stamp once impermissibility has been established. And the court must, therefore, in almost all cases, forfeit all, because it has no discretion to forfeit part. In those circumstances, Section 3 is firmly engaged. Let me begin developing that submission by identifying what is common ground. If your lordships would take up the core bundle, please, tab 5, and turn to Mr. Justice Walker's judgment at page 221.
What paragraph?
I'm sorry, Lord. Page 221, paragraph, it starts by setting out Article 1, Protocol 1, and then moves to paragraph 47. It is common ground that a forfeiture order under Section 58 can only be made if it complies with A1P1. Applying the principles in Sporrong and Sweden, the Magistrates' Court must determine whether a fair balance is struck between the demands of the general interest of the community and the requirements of the protection of the individual's fundamental rights. The search for this balance is inherent in the whole of the Convention and is also reflected in the structure of Article 1. The Court of Appeal analysed the relevant principles in Lindsay. Paragraph 52, my Lord Phillips stated, the Commissioner's policy involves the deprivation of other people's possessions. Under Article 1 of the First Protocol, such deprivation will only be justified if it is in the public interest. More specifically, the deprivation can be justified if it is to secure the payment of taxes or other contributions or penalties. The action taken must, however, strike a fair balance between the rights of the individual and the public interest. There must be a reasonable relationship of proportionality between the means employed and the aim pursued. All of that is common ground. The operation of A1P1 in the context of confiscation proceedings is demonstrated by a decision in Authorities 1 at tab 11. This is the case of Customs and Excise and Newbury. It is one of the 3 or 4 seizure of car cases that have reached the law reports. The Customs seized the car that was being used to smuggle or move the tobacco. The Magistrates' Court ordered the forfeiture of the car. There was an appeal to the Crown Court, and the Crown Court allowed the car owner's appeal on the basis that it had a discretion if it considered forfeiture disproportionate, and the commissioners appealed, I think, to the Divisional or Administrative Court. And the judgment of Lady Justice Hale, paragraph 21, is of some assistance. Page 2142, paragraph 21. We can understand, Lady Justice Hale said, why the commissioners might want to keep this issue under their control, subject to a specialist tribunal. The courts are used to finding facts and applying their judgment to the consequences of the facts found. There are many other contexts in which courts at all levels have to make the sort of judgments required here. Section 7.1b of the Human Rights Act is to have any meaning. How can a court which is seized of the issue whether property is liable to confiscation by the state not have a duty to consider whether such liability would be in breach of the owner's convention rights? If it would be, the court cannot condemn the property. It would itself be acting in breach of convention rights. It is not compelled by CIMA to do so because the concept of liability to forfeiture is capable of incorporating more recently enacted convention rights. The argument that the condemnation and restoration procedures taken as a whole are sufficient to provide full jurisdiction for the purpose of Article 6 of the Convention does not meet the point that seizure and condemnation are themselves acts of interference with the peaceful enjoyment of property, and therefore acts incompatible with Convention rights if forfeiture is disproportionate. It is not sufficient to wait until an owner seeks a review and then exercises his right to appeal. The right to peaceful enjoyment is engaged from the moment of seizure and continues thereafter. The initial act of seizure may not be disproportionate because the commissioners are entitled to investigate, but the interference should cease once an opportunity is available properly to consider whether it complies with convention rights. The court should not be asked or expected to make an order which is not only in breach of those rights in itself, but also legitimates continuing breach by the commissioners unless and until the review process takes place. And that is a summary of the approach that we submit is required by the Convention of the court that hears an application pursuant to Section 58. If the Court of Appeal's construction is correct, the court is disabled from considering questions of proportionality. One can test that by considering a case in which a very substantial donation, perhaps running into millions of pounds, is made by somebody like Mr. Bowen, who could be on the register, but for some unfortunate reason or unfortunate slip is not on the register. If the Court of Appeal is right, then that should have been picked up by the political party. And if an application is made, the court hearing that application has no alternative but to forfeit a sum which might run into 7 figures. There's no cause, no justifiable reason for imposing what is effectively a massive penalty. And considerations of proportionality would require a court to impose either a lesser penalty, a much more modest penalty, or to impose no penalty at all. But the court is simply prevented by the Court of Appeal's construction from considering such issues. That appears, in our respectful submission, to be a fatal objection to the Court of Appeal's construction, which would cause, if necessary, this court to say that Section 3, which was not referred to by the Court of Appeal, destroys the Court of Appeal's construction and makes mandatory a different construction. What is the Commission's answer to that apparently fatal objection to the Court of Appeal's approach? The Commission, I think, Mr. Beloff, and I'm afraid Mr. Beloff will correct me in due course if I have it wrong, but the Commission advances in effect 2 answers to the proposition I've put forward. First, there are passages in the Commission's case which suggest that the forfeiture of the entirety of a donation is necessarily and more or less by definition proportionate, because it is the forfeiture of a sum which the political party should not have received. But that argument rests on the fallacy that I've already sought to expose, which is essentially that in some cases, and this is one of them, the the donation is not within the scope of the relevant mischief, and there is no reason in substance, no substantial reason why the party should be deprived of the benefit of that donation. So that's no answer. The second submission that is advanced in the Commission's printed case rests on the concept of margin of appreciation. And it is said that in invoking Section 3 in this context, it is necessary for UKIP to persuade the court that Parliament's judgment as to what the court hearing a Section 58 application can and cannot do was without reasonable foundation. It is said that unless we can show that, then Parliament's judgment as to what is permissible is within the margin of appreciation or within the margin of discretion and must be honoured and given effect to by a domestic court. The case cited in support of that submission, principally cited in support of that submission, is in Authorities Volume 3 at tab 44. It's a case concerning the nationalisation of Northern Rock. It was a claim brought by various parties who owned shares in Northern Rock and were unhappy with the provisions for compensation. Lord Justice Laws provides a very full analysis of the operation of Article 1, Protocol 1 in this field. I think I can take up the judgment at paragraph 55. At the start of paragraph 55, Lord Justice Laws expresses the position as follows. The overarching principle is the first, the need to strike a balance between public interest and private right. The other two, proportionality and the margin of appreciation, provide the means by which the balance is struck. Your Lordships will read on. In paragraph 56, Lord Justice Laws considers the various different contexts in which the concept of margin of appreciation may have to be assessed. He distinguishes between what he calls the microeconomic setting, where a single property is taken, in which case proportionality is likely to require payment of market value or something close to it, and there will be a very modest margin of appreciation. But he identifies other cases in which the objective of the deprivation is much broader, perhaps as a matter of high politics, and I can see the force of the point that our case is in the latter category. And he says that in such cases the margin of appreciation allows a flexible approach to the right protected by A1, P1. And then in a passage that certainly I found very instructive, he provides a note on the margin of appreciation and its relationship to the approach taken in the domestic courts. Paragraph 57, he notes that the margin of appreciation is the doctrine of an international court. And over the page, paragraph 58. he asks the question, since margin of appreciation is an international court doctrine, how does it inform the decision of a municipal court? He says that these courts of this country, are obliged to take into account the jurisprudence of the Strasbourg court. In fulfilling this duty, it seems to me that we ought, if we can, to ascertain the scope of the discretion, the width of the margin which the Strasbourg court would be likely to accord to the legislature in enacting the compensation provisions of the 2008 Act. If they lie within the margin, other things being equal, there will be no violation of A1P1. And in paragraph 59, he equates the international law doctrine of margin of appreciation with the municipal doctrine, the margin of discretion or deference, which our courts will pay to the judgment of public decision makers in matters of discretion or policy. And he goes on to refer to the James case, which is the Leasehold Reform Act case, in which the Duke of Westminster's estate unsuccessfully challenged those provisions. And that leads him to cite from a dictum from the James case, which ends with the words on which the Commission found their submissions, namely, manifestly without reasonable foundation. Also, I've gone to that passage not because it advances my submissions, but because it sets the context for the submissions that one finds in the printed case of the Commission. What I take from the Commission's printed case is that they are founding on that analysis and on the concept of testing whether Parliament's judgment is manifestly without reasonable foundation. And they are submitting to the court that while it might be said, and I have said, that this Act operates in a less than perfect way because it deprives the court of the ability to reach a proportionate decision, that nevertheless it is for Parliament to make a judgment as to how this Act should operate, and unless we can show, and they say we can't, that judgment is without reasonable foundation, our case on Section 3 falls away. Well, I have two answers to that submission. The first is this. The vast majority of the Section 3 cases that this Court and the House of Lords have considered over the last 10 years or so involve an Act whose language is unequivocally clear. Take the Rent Act case, Gaydin, take the Terrorism Act case, take the Rape Shield case. In all those cases which gave rise to problems under Section 3, the language was clear, and the court was being asked to apply quite an extreme construction of Section 3, and to use Section 3 to reach a construction which was not consistent with the intention of Parliament as manifested by the language of the Act. And the court was able to do that, applying Section 3. In cases of that sort, the court is able to judge from the language of the Act what Parliament's judgment has been, and certainly, I would accept, has to have regard to the principles as to margin of appreciation and margin of discretion or deference that Lord Justice Laws is expounding in this passage. This case, I would suggest, is of a different type. This is a case in which the language of this Act is not clear. We would actually, subject to my primary submission, which is that it is clear, and the position is perfectly straightforward. It's entirely clear, and Mr. Justice Walker was plainly right. But if I'm wrong about that, and if it's possible to take a different view of the Act, as the Court of Appeal did, then one is in a position in which there are two possible readings to place on the Act. It's a case in which, at its highest from the Commission's point of view, the language is ambiguous. What I draw from that is that one cannot take from the language of the Act a clear identification of Parliament's judgment as to the way in which the Section 58 jurisdiction should operate. It follows from that my learned friend's point on the margin of appreciation just doesn't arise at all, because he is unable to establish that Parliament clearly, given the language that it used, intended to achieve the result that I say involves necessary disproportionality. He can't show that. In which case, this court is left to consider which of the two tenable possible constructions of the language of Section 58 is to be preferred. This court does not have to resort to the extreme use of Section 3, which involves using Section 3 to impose a construction which is inconsistent with the express language. This court is engaged in a less onerous exercise of simply deciding which of two possible constructions should be preferred. If the court is left in any uncertainty, having considered the various submissions that I have already advanced, then the court can apply Section 3, and should apply Section 3, to reach the construction for which we contend. Why? Because that is the only construction which allows the magistrate who hears a Section 58 application to give effect to the principle of proportionality, which is established by all the Article 1, Protocol 1 jurisprudence.
By that, do you mean you read it as allowing a partial forfeiture? Or what?
I'm assuming, of course, that the court is against me on all the submissions I've advanced so far. I'm addressing now both the issue as to the width of the discretion and the issue as to partial forfeiture. The two have to be taken together. For the court hearing the Section 58 application to be able to deal proportionately with this type of case, where there's been a donation that is not a foreign donation, it must, we submit, first of all, have a wide discretion to take into account all the potentially relevant considerations that Mr. Justice Walker identifies. And secondly, if he considers it appropriate, to make a partial forfeiture order that gives effect to the deterrence purpose that we have conceded is to be taken into account. That is the way in which a proportionate outcome can be reached, and the Court of Appeal's construction deprives the court of the ability to reach such an outcome, and therefore deprives the court of the ability to act lawfully and in compliance with convention rights.
Supposing that the position were that the court thought that the sort of ordinary meaning, not Section 3 kind of meaning, was that the forfeiture provision envisaged forfeiting the whole sum. Yeah?
Yes.
And then it had to consider Article 3, Section 3, and say, well, how do I make that work? Well, the first question would be, can I make that work proportionately? Isn't that right?
Yes.
Now, supposing I said, well, I can make it work proportionally by refusing.
Yes.
Is that all right? I don't get to Section 3 at all in that situation.
You wouldn't then get to Section 3. This court might regard that as a very unsatisfactory outcome, because it would, as I've submitted, it would place the magistrate in a difficult position. He would have regard to the purposes of the Act, and he would have regard to the need to deter if appropriate, but he would also have to have regard to the need to reach a proportionate outcome. And he might end up saying to himself, well, the proper result here is somewhere between all or nothing. But because all is disproportionate, and because I don't have the partial forfeiture discretion, I have to say nothing.
Can I ask you one or two questions on this area, a bit technical? First of all, Article 1 confers protection on every natural or legal person. Who's the legal person who is protected by Article 1 here? Is it the Treasurer who holds the funds in trust?
It is either the members of the party who are members of the unincorporated association, which is the party, or it is the officers of that unincorporated association, and probably specifically the Treasurer, who hold the money on behalf of the association.
Right, that's the first question. I anticipated that is what you would say was the answer.
I
have problems with
yes.
legal persons and unincorporated associations, but there we are. I suspect Strasbourg wouldn't have a problem in this situation. The second point is this. Mr. Bowen gives £10,000, donates £10,000 to UKIP. Does the property then pass to UKIP there and then?
When he transfers
Yes.
the money
The
to
treasurer
UKIP?
puts it into his bank account, or the party's bank account.
Yes, it is transferred to UKIP. I've asked myself, and I'm sorry not to provide a more direct question. I've asked myself whether that property is impressed with some sort of trust, because clearly it would not be open to the treasurer to spend the money on a new kitchen for himself or the chairman of the party.
But let's assume he holds it for the party.
He holds it for the party, yes.
Now, the Act requires that to be returned, and therefore deprives the party, requires the party to be deprived of that asset.
Yes.
Now, you wouldn't suggest, would you, that that is objectionable as infringing Article 1 of the First Protocol?
The requirement that the money be returned to the donor
Yes.
because it's an impermissible donation.
Yes.
No, I would not suggest that, no.
The minute you get to day 31, then it is impermissible to remove the same sum from the party into the coffers of the common fund.
To remove the money into the coffers of the common fund, yes, it is. Because if the money goes back to the donor because of an infringement of the rules laid down by the Act, then that's fine. The donor has the money back. He's not out of pocket. And it's easy to forget the position of the donor, but he's here in Gordon. He may want me to say that he is deeply disturbed at the idea of the monies that he'd earmarked for UKIP's use going to the state. The money goes back to the donor. If he's a foreign donor who cannot permissibly pass money to a political party, then that's that. There is no lawful means, subject to moving to this country or whatever, there's no lawful means by which he can do that. If he's not, if he's like Mr. Bowen, then he can simply rectify whatever problem was preventing him from being a permissible donor. And if he wishes to do so, he can make the donation again and the party gets the benefit. That's fine. That's the way it should be. But what's unacceptable is we say, or what's potentially disproportionate in this type of case, is for the money to be seized by the state. So the donor doesn't get the benefit of his political party of choice using the money, and the party is deprived of that benefit. I think that concludes my submissions on Section 3, which I've taken relatively shortly in the light of the fact that I have submitted as emphatically as I can that this is really not a case in which your lordships need to be troubled by Section 3. Can I now conclude my submissions by looking briefly at one or two passages or some passages in the Court of Appeal's judgment which I respectfully submit are clearly flawed and give some indication as to why it was the Court of Appeal came to the wrong conclusion. I'm not, given the time, I'm not going to take your lordships to Mr. Justice Walker's judgment. I know that it will have been read, and the lordships will understand that subject to one or two qualifications, we accept Mr. Justice Walker's analysis of the discretion, and we simply submit that it is very plainly a careful analysis of the discretion, and we say that it is broadly a correct analysis of the discretion.
I thought Mr. Walker was against you on the all or nothing point.
Yes, that's the qualification. That's one of the qualifications that I have in mind, Lord. We don't accept him on his.
Where is it? Which paragraphs does he deal with that in?
117. Thank you.
And then, your predecessor in the Court of Appeal, the whole of the Court of Appeal accepted. Everybody accepted that was correct for the Court of Appeal. In the Court of Appeal, is that right?
That's correct, Lord. Yes, that is correct.
And the other point is that he was against you on reasoning, and you didn't cross-appeal to the Court of Appeal on that.
That is correct, Lord.
So that, if we were to go back to Mr. Justice Walker's judgment, it would have to go back to the district judge.
Unless I could persuade this court to take a very indulgent line, my lord, then yeah, I think it would, yes.
Mr. Beloff, I appreciate, submits that the thing is so clear on the district judge's findings that we could decide it that way, but you're not suggesting we could decide it in your favour.
No, Lord, I think given the course this litigation has taken, I can't suggest that. It would have to go back. Turning then to the Court of Appeal judgment, making one or two points in relation to it. Can I go first to paragraph 14, page 191. And I simply make the point, it's perhaps a rather cheap point, but I make the point that in paragraphs 14 to 18, the Court of Appeal has quoted various extracts from the Neil report, but has not quoted or expressly referred to what we say is the key passage in the Neil report, which is that which identifies the reason for the ban on political donations as being the fact that it is only people with a genuine stake in the country who should be allowed to donate to political parties. Then if I could move to paragraph 33, please. Under the heading comment on the legislative history, in paragraph 33, the Court of Appeal describes the shift from the test of eligibility to get onto the register to a test of actually being on the register, and observes that that was quite a significant change. And then paragraph 34, the Court of Appeal says this: even more significant was the change in relation to the forfeiture proposal. The Neil Committee recommended that for deliberate acceptance of a donation from an impermissible source, there should be liability for forfeiture of a sum not less than the donation from the receiving party's funds, and refers to the 10 times the overspend penalty that was contemplated. It was envisaged that the forfeiture power would be available even if the receipt were innocent or inadvertent, but the courts would clearly take into account the degree of culpability in setting the level of forfeiture. Then Sir Paul Kennedy says, I'm inclined to agree with Mr. Newman that the Neil Committee probably envisaged courts having quite a wide discretion in relation to forfeiture. But in the white paper and the statute, the position changed. The proposal that there should be power to forfeit an amount greater than that received was abandoned without explanation. But paragraph 4.15 of the white paper clearly envisaged a power to order forfeiture of a sum equivalent to all that had been received, that sum, whether the sum was accepted knowingly or not. The analysis of the Court of Appeal appears to be that the Neil Committee contemplated that the court should have quite a wide discretion. We agree. But the position changed in the white paper and the statute. But in our submission, there's nothing in the passage in the white paper that we have looked at which in any way indicates an intention to move away from a position in which the court had quite a wide discretion. The matters that apparently are relied on by the Court of Appeal don't lead to that conclusion. The fact that the power to forfeit an amount greater than that received was abandoned does not lead to that conclusion. And the fact that the white paper envisages a power to order forfeiture of a sum equivalent to the donation, whether the sum was accepted knowingly or not, does not itself lead to that conclusion. So there's with respect, an unjustified assertion there that one can find in the white paper a clear indication of an intention to move away from the Neil Committee's wide discretion to a much narrower discretion.
I suppose this could be said, could it? If you look at paragraph 542 in the Neil report,
Yes.
they first of all say that if a party were to be guilty of a deliberate acceptance and so on, criminal sanction should attach, and a sum not less than the donation should be liable to forfeiture.
Yes.
Then later, they say a forfeiture power should also apply, even if the receipt were innocent or inadvertent.
Yes.
But the words used in the statute, it might be said that when the Neil report used the expression a sum not less than the donation, they meant what it said. And when that was used in the white paper and the statute, it meant what it said in the same way. And that when the Neil report were talking about a forfeiture power should also apply even if the receipt were innocent or inadvertent, it was only in that context that there would be a discretion. So that when they used the expression a sum not less than the donation, they intended to mean what it said, namely a sum not less than the donation.
Yes. Well, the phrase used in the Act, I think, is a sum equivalent to the value of the...
Equal to the value.
Equal to the value of the...
Yeah, but both in the Neil report 542 and in the white paper 415, it does use the word liable.
Yes.
Which, to me, suggests that's the worst that can happen, not that it has to happen. I don't think liable is a word that sits easily with all or nothing.
It does not sit easily with all or nothing, my Lord, and it does not sit easily with a very narrow discretion. I read liable in those papers as meaning susceptible to. I think that's the sense in which it is used. My submission in relation to the connection between the Neil Committee's recommendation as to forfeiture and the White Paper's treatment of that subject is broadly this. The Neil Committee adopted a dual approach, very severe approach in relation to deliberate acceptance of impermissible donations, and a very flexible approach that would be sensitive to culpability and no doubt many other issues in relation to innocent or inadvertent receipt. The White Paper did not expressly address the dual structure of the Neil Committee's recommendation, but simply collapsed both types of case, deliberate receipt, a much more serious type of case, deliberate knowing receipt on the one hand, and innocent/inadvertent receipt on the other hand. The White Paper collapsed both those types of case into one broad case and suggested that the court, or proposed wording, which was accepted, that said that the court may order forfeiture in such a case. It's reasonable to take from that the intention behind the White Paper and the drafting of the Act contemplated, just as the Neil Committee contemplated, that in relation to the less serious type of case, where the receipt was innocent or inadvertent, there should be a broad discretion. One can't find anything in the White Paper or the Act which negatives that and which suggests that in the less serious cases the discretion is somehow very narrow, as the Court of Appeal has held. So I make that submission as to the Court of Appeal's treatment of the shift in the position from the Neil Committee's report to the White Paper. Then, if I could ask the Court to turn over the page and look at paragraphs 40 and onwards. Excuse me. In paragraph 40, the Court of Appeal says this: Mr. Beloff points to the fact that any donation received from an impermissible donor is a donation which, from the outset, the party should never have received.
Sorry, paragraph 40.
40, my Lord, 40.
Yes, yes.
Second line.
Yeah.
A donation which, from the outset, the party should never have received. The use of the word never there is rather curious. It would be more accurate to say that it is a donation which, at the outset, the party should not have received. And then broadly the same wording reappears in paragraph 42, 4 lines down. The party has 30 days to check, etc. And if after that period an order is made for it to forfeit to the state an amount equal to the value of the donation, that is only ensuring that it does not have the benefit of a donation which it should never have retained. Again, the use of the word never is oddly emphatic.
Why do either of those matter? I mean, the point is an obvious one, and who cares which way they... I mean, why does it matter?
It matters, my Lord, because these passages, and there are others in the Court of Appeal's judgment, seem to reflect a perception that the political party, UKIP in this case, could never properly have enjoyed the fruits of the generosity of Mr. Byrne. There's nowhere in this judgment do you find any recognition by the Court of Appeal of the underlying reality of this case, which is that it would only have taken a routine application to the registration officer to restore Mr. Byrne to the register, to create a situation in which the donation could lawfully be received.
I mean, you really think they overlooked that?
Well, if they didn't overlook it, my Lord, I'm sure they didn't overlook it entirely, because the point that I'm sure was made by my predecessor vigorously, so I'm sure that it wasn't overlooked. The submission I'm making is that point is not dealt with squarely anywhere in this judgment. Paragraph 45, last 6 or 7 lines on that page. Unless the normal consequence of an impermissible donation being brought to the attention of the court is an order for forfeiture of an amount equivalent to the value of a donation, parties are in reality free to disregard the provisions of section 54 and 56 with impunity, says the Court of Appeal. We respectfully criticise that is not a fair analysis. Once it is appreciated that the court should have a wide discretion and a flexible discretion, it is clear, we submit, that parties cannot freely disregard the provisions of section 54 and 56 with impunity. If an impermissible donation exposes a party, as it does, to the risk of a section 58 forfeiture application, then the party is immediately exposed to all the costs, risks that flow from such applications. It's exposed to the risk of a partial forfeiture order imposed on deterrence grounds.
Of course, the Court of Appeal wasn't considering anything other than the all or nothing case.
That's true, Lord. That is true. It was resting. It certainly was.
I'm not sure which way that point works, but
it's true. That is true, Lord. The Court of Appeal was obviously analysing the case on an all or nothing basis, and therefore was concerned that if our submissions prevailed, parties might get off scot-free.
In that context, you can talk about impunity, but if, on the other hand, what you would call a proportionate forfeiture, if there is such a thing, could be achieved, then one couldn't say that. No,
the point about impunity would go. Moving towards the end, Lord, paragraph 46, the Court of Appeal there shortly dismisses the proposition that it is relevant to consider whether the donor is making a foreign donation, on the basis that magistrates' courts should not, in my view, be seduced into ignoring the wording of section 55 and attempting to resurrect a test which, for good reason, the Neal Committee and Parliament did not adopt. With respect, that is not a fair characterisation of our arguments. We have never suggested that the test that is actually imposed by the Act could properly be ignored and that matters should be dealt with as if the Neal Committee's recommendation were accepted. We've always wholly accepted that the non-compliance with the rules is something to which the court must have regard. We're not trying to resurrect the Neal Committee's test. We're simply saying, your Lordships have the point, that in construing the Act, the court must have regard, must pay close attention to the nature of the mischief at which the Act is directed. Lords, that's all I want to say about the Court of Appeal judgment. The remaining issue in the case, if it is open to my learned friend, is what he calls the irrationality issue, whereby he hopes to persuade this court that even if we are right on construction issues, the case on the facts against UKIP was so overwhelming that it should be decided here, that it would be irrational to make any order other than a forfeiture order. The Lordships would have seen from our case that we don't accept that it's open to my learned friend to make that point, and we also submit that the argument is quite hopeless, because if we are right on construction issues, the facts would clearly require to be closely investigated by a fact-finding tribunal before the order which the Commission seeks could possibly be made. I would be, having regard to the time, I would be happy, if the court were happy, to deal with that point, if I need to deal with it, in reply, having heard Mr. Beloff develop his submissions.
Yes.
In that case, my lords, unless I can assist further, those are my submissions.
Thank you very much. Mr. Yekinsu, is there anything you wish to add? Very well, we shall adjourn and look forward to hearing Mr. Beloff's submissions tomorrow.
Difficult when they're clearly desperate for this shut.